Hi, Kyla. How are you?
I'm good. Thank you so much for having me.
Well, it's very nice to see you. And we're recording this interview soon after we finished our impaired driving series for Wicked, which was really very successful. So we want to thank you for taking the time. Like over the past 3 weeks, Kyla was presenting on impaired driving for Wicked members and for people who registered who were interested in the program. So we thought once we completed that presentation, that will be nice to register another interview here. It's a mini series, but it's not really a series. It's just an interview here, a condensed interview with Kyla on impaired driving cases. And here, well, the intention of this interview is for Kyla because you have a niche in impaired driving cases, so you're really and you just won an award, so congratulations on that. Um, so we decided that you're going to be giving tips to lawyers and to the public about impaired driving cases, some of the things they need to pay attention to and they need to look out for in these types of cases. So let's start then, Kyla, by talking about when a person gets stopped for impaired driving cases. So how that first interaction with the police happens.
Yes. So, I mean, usually in the vast majority of cases, the first interaction with the police is going to happen either as a result of the person driving through a check stop or some sort of a pullover. The majority of the ones that I see, we don't do a lot of roadblocks in British Columbia. So the majority of the ones that I see are people pulling out of the parking lot of bars and liquor stores where police will kind of wait and stop them for the purposes of checking their sobriety, or cases where police officers stop individuals because they think that they've committed an offense. Maybe they're speeding or they make an illegal U-turn. They roll through a stop sign while making a right turn, like we all do, and
Mhm.
they end up stopped by police. And so that's sort of the beginning of the interaction. From there, and again, the vast majority of cases, the police are going to look for grounds to determine whether or not somebody is impaired. And they do this anytime they conduct a stop, whether it's 8 a.m. in the morning or 3 p.m. in the afternoon, they're going to be looking for symptoms of impairment. And they can go one of two ways. They can form a suspicion that a person has either alcohol, drugs, or a combination of the two in their body, or they could form reasonable grounds to believe that somebody's ability to operate the vehicle is impaired by alcohol or a drug or a combination of the two. And what opinion they come to is going to determine what type of demand they make for either a roadside breath or saliva sample or a standardized field sobriety test, or a sample to be provided at the police station or a drug recognition evaluation test. They can also choose to just give you a demand at random. This is called the
Mhm.
mandatory demand. It was brought in December 2018. And anytime a police officer is dealing with somebody who is operating a motor vehicle, as long as they do it immediately upon stopping them and they're engaged in the lawful execution of their duties, they can say, you have to blow into a roadside breathalyzer, and it's a criminal offense to refuse to blow. So that's sort of how the investigations tend to transpire. You're stopped or you're investigated
But the
by police.
police also must have the device on them.
Yes, to do the mandatory
Yeah.
demand, they have to have the device. And as a matter of like practicality, to do any type of roadside sobriety testing, they do have to have the device. The law
Yeah.
doesn't say that explicitly, but it says that the test has to be administered immediately and that the demand has to be made immediately. So the Supreme Court of Canada ruled on this late last year in a case called Bro, that essentially the officer was waiting for the device to arrive.
Mhm.
Court said that's not immediate, it's not a justifiable delay, and they found that that demand was unlawful.
All right. So then what happens after that? So once you have that demand.
So if there's a roadside demand, after the roadside demand is conducted, assuming you don't pass the
Yeah.
test, if you pass, you're on your way. But if you get a fail reading on the roadside breathalyzer, you're going to be arrested. You're going to be read a subsequent demand for samples at a police station in a criminal investigation. And then you're transported back to the police station, or sometimes they have these buses that have the testing equipment on them. That's pretty rare. Most of the time you're popped in the back of a police car and taken off to the police station. You get the opportunity to speak to a lawyer if you want at the police station, which for anybody listening, you should always exercise that right. And then once you've spoken to the lawyer, they conduct breath samples at the police station. And they're required to take a minimum of 2 samples
Hmm.
at the police station. So a lot of people think, oh, I blew once, I don't have to do it again. You actually have to do it as many times as they feel is necessary. So it's usually a minimum of 2. Lots of cases, though, they do 3, 4, sometimes 5, depending on if there's problems with the instrument, errors or messages that they need to address, or if the readings are disparate, they need to retake the readings to try and get them to agree within a certain parameter.
Now, but on that point, going back a little bit to the approved screening device, because sometimes in many cases we see individuals having a hard time blowing into the device. So that's another problem as well. So maybe if we can talk a little bit about this issue.
Yeah, so it's a criminal offense to refuse to provide a sample, but the law treats refusing and failing to provide a sample as equivalent. So essentially, if you don't successfully provide a sample, you're likely to end up charged with refusal to blow. You can argue, though, that you had a reasonable excuse for not providing a sample, and the law recently changed with respect to reasonable excuse on these. So now all you have to do is raise an error of reality to the existence of a reasonable excuse, and then the burden falls on the Crown to disprove it. So if you have some sort of a medical condition, I deal with so many cases of people, especially like post-COVID, with medical conditions, COPD, asthma,
Yeah.
um, even people who are really small stature. There have been some studies that have shown that especially small women, like, you're 5'1" and 85 pounds, you're not physically capable of producing enough air to register a reading on the device. This happens a lot with elderly people as well, where they struggle to blow because your breathing capacity diminishes as you age. And the police, their manual doesn't train them on any of this. And you see cases where police say the most horrific things to people who are doing their best to provide a sample who may have a medical issue, saying a 2-year-old with one lung can blow, or my 85-year-old grandma can do it. And I guarantee you, they've never tested a 2-year-old with one lung, nor
Hmm.
have they ever tested their 85-year-old grandma. But they're trained that everybody can do it, even though that's not actually scientifically true.
Yeah. Yeah. And before we go to what happens at the police station, I also wanted to ask you, Kyla, because this is something that people, members of the public, sometimes struggle with in the impaired driving cases, that they can get charged when they were sleeping in the car, like they weren't even actually driving. So maybe if we can talk a little bit about this point and clarify it.
Yeah, so under the criminal code, the definition of operating doesn't accord with what we think of when we hear operating. When we hear operating, we think of driving, but it actually is a broader definition that includes things that fall short of actual driving. So this used to be known as care and control.
Hmm.
And it essentially is anytime you're in the vehicle with the means to set the vehicle in motion, usually in the driver's seat, but there have been care and control cases made out where somebody's not in the driver's seat, but they still have the means to put the vehicle in motion, or where there's a realistic risk that the vehicle could be set in motion. So it really comes down to often in these cases what your intention is. But the courts have also said that the intention of a person is limited by their state of intoxication, in that an intoxicated person in the driver's seat of the vehicle with the keys essentially always poses an inherent risk that they're going to drive. So unless there is some evidence of a concrete and reliable plan
Hmm.
and steps taken in furtherance of that plan, just being in the driver's seat, I'm going to sleep until I feel sober, is not in and of itself necessarily enough to overcome a conviction. Now, the reality is that lots of judges often don't like convicting people who are trying to do the right thing. But especially with like roadside prohibitions and things like that, you see people having their prohibitions upheld just for having that plan that we all think is a safe thing to do.
Right. And what if they were sleeping in the back seat?
Sleeping in the back seat is better because it shows like a specific intention not to be driving.
Yeah.
But again, there's still the risk that you could wake up, you could still be impaired, and you could decide to drive. You see a lot of cases where people are charged with impaired driving in the early morning hours, where they
Hmm.
got a couple hours sleep, they woke up, they felt sober, but their blood alcohol level was still over the limit. And
Right.
even if you're not impaired, you can be convicted of being over the limit.
Right. And then there's also the within 2 hours, like if we can also clarify that, which can be confusing as well.
Yes, so there's sort of two separate standards. So there's impaired while operating the vehicle,
Mhm.
and then there's being at or over 80 milligrams of alcohol and 100 milliliters of blood within 2 hours after operating a motor vehicle, which
And this
technically,
gives people a really hard time.
oh,
Yeah.
people do not understand it. They say,
Yeah.
I can't be charged for going home and having a
Yeah.
drink, or if you're in an accident and you kill somebody, go home and drink and the police won't catch you. That's why they made it illegal, because people
Yeah.
were giving that advice and
Yeah.
police officers were doing it and getting away with things. So they changed the law to make it illegal to be over the limit after driving. But the reality is that that's capturing all sorts of innocent conduct, right? You have a hard day at work, you stop at the liquor store on your
Yeah.
way home, you buy a bottle of whiskey, you park your car and you drink because your day sucked, and technically you've broken the law.
Mhm.
And if you get charged in those circumstances, if the police knock on your door and they say, we got a report about you driving badly, or you swore at somebody in the parking lot of a liquor store and you smell like alcohol, and they conduct the impaired investigation and you provide samples and are over the limit, you could be charged. And then the burden falls on you to prove a number of things that are really difficult to prove. First of all, you have to prove that you had no reasonable expectation that you would be given a demand for a breath sample, which that's usually the easiest one. Because
Yeah.
if you're in an accident and you flee the scene, it's hard to say, I didn't think the police were going to come and investigate me, because why did you leave? But in the innocent circumstances, that's easier to prove. But you also have to prove two other things. The first, that you weren't over 80 at the time that you were driving. So you have to give some evidence of what, if anything, you drank before you drove. And then also that the amount of alcohol you drank after you got home and started drinking is consistent with the readings that were obtained on the breathalyzer. So if you say I had one beer when I got home
Mhm.
and you blew 240
200.
milligrams,
Yeah.
that's not going to fly. They're not going to say, well, we don't accept that. So it's a huge burden that you have to discharge. And it essentially reverses the onus in cases where people are found after they drove.
Right. All right. So this is what happens at the stop level. But then once it was determined on the scene that they're over 80, um, then what happens? So we know that they will go to the police station. So you mentioned a bit that there's going to be another test here. So let's talk a little bit more about what happens at that point.
Yes. So typically at the police station, there's sort of two divergent practices
Mhm.
in Canada. You get your lawyer call first. That's going to happen. Lots of places they'll do the lawyer call roadside now because the law has been developing to require that. But once you're at the police station, in some provinces, they will start a 15-minute face-to-face uninterrupted observation period before taking a first sample. BC, they do this. Alberta, they don't do it. Ontario, it seems to go both ways.
Mhm.
But they're permitted to do that. And in fact, they're supposed to be doing that
Yeah.
because it's ensuring that you're not doing anything like burping, belching, vomiting, regurgitating, taking anything by mouth that could interfere with the results. And it also gives the police a super great opportunity to look at you under the bright lights of the police station to go, oh, your face is flushed and your eyes are bloodshot, and to engage in conversation with you and ask you questions and say your answers didn't make any sense, or you slurred your speech a lot, or you were slow to respond. Um, so it's basically like a little bit of a trick at the same time
Yeah.
that it's a scientific procedure. And then you blow into the instrument at the police station. And then between the two samples, there is a legislative requirement
Mhm.
that there is a 15-minute period. So the two samples have to be taken, the minimum of two, have to be taken 15 minutes apart. The two readings have to agree within 20. So if you get one reading that's 100 and one reading that's 130, they need to take another sample because they don't agree. And they also have to do the instrument has to do a bunch of checks of an internal and an external standard to check its calibration
Yeah.
at the time that the test is done.
And in terms of that test as well, they have to, like, you must comply and do that test as well, just like the roadside one.
Yes, you must comply. The best way that it was explained to me when I first started in this area is my principal at the time said to me, there's two demands and there's two types of tests. And I was like, oh, okay, there's two that you have to do. It's not always the case, but that makes a lot more sense than thinking, well, I already blew at the roadside. Why do I have to blow again? I already did what they asked me to do. There's two. So just think about it that way.
Now, actually, on that point, there are cases where there is no approved screening device test, but they're brought to the police station. So let's talk about these situations.
Yes, so that would happen in circumstances where an officer doesn't need the approved screening
Mhm.
device to get the grounds. So like I said earlier, it's the approved screening device is done in circumstances where the officer has a suspicion, a reasonable suspicion that there's alcohol in a person's body. Whereas if they have reasonable grounds to believe that a person is impaired, they can skip past that. And that would happen, I often see that in cases of accidents where people, are walking around badly, they're
Yeah,
stumbling, their speech is slurred, they display a number of indicia of impairment, and the officer says, okay, I know that person's drunk, basically.
yeah. And also in terms of maybe the distinction between reasonable suspicion and reasonable grounds, because that's also important in impaired driving cases.
Yes, and sort of drawing that distinction, I feel like there's been more judicial ink spilled
Mhm.
on whether there's a suspicion versus reasonable
Grounds.
grounds than anything else. But the distinction is a reasonable suspicion is a suspicion that's objectively reasonable based on the information known by the officer, that's subjectively held by the officer, that there's alcohol in a person's body. You don't have to think they're impaired by it, just the presence of alcohol in their body at the time that they were operating the vehicle is enough. You also have to have a suspicion that they operated the vehicle within the preceding 3 hours. Um, for impairment, you need to have reasonable grounds, so a credibly based probability. And it also has to be objectively reasonable based on things known to the officer at the time, that a person's ability to operate the motor vehicle is impaired by alcohol. So, not just that there's alcohol in their body, but that the alcohol is actually having a physical effect on them that's deviating them, or a cognitive effect that's deviating them from their norm. And it kind of doesn't make a lot of sense, the things police rely on for this, because if you look at, fumbling with documents or slurred speech or a
Yeah.
flat face, those don't say anything about your driving ability. But
Mhm.
we know that there's signs of intoxication and that your driving ability, everybody's driving ability, becomes impaired at 80 milligrams of alcohol and 100 milliliters of blood. So essentially, what police are looking for is the physical signs of intoxication you would expect to see at that blood alcohol level.
All right. Now, for some individuals, though, they have a condition. It could be a medical condition that could appear as a sign of impairment. So let's talk a little bit about that situation.
Yeah, so a medical condition that can appear as a sign of impairment could be a defense to an impaired driving
Hmm.
charge. If the judge is saying, you were behaving in this way, so I think you're impaired, you can raise that as a defense, but it's not necessarily a defense to the officer's grounds because it's
Hmm.
only based on the information that's in the officer's knowledge at the time. There are exceptions to this. For example, if the officer knows you and they know about
Yeah.
your condition, or if it's a parent, you have somebody with a physical defect that you would be able to see, then the officer has to take that into account. Or if you tell the officer, if you raise it with the officer at the time, you say, "Hey, I wrecked my knee playing football last weekend," then the officer has to take that information into account before forming their grounds. It requires the officer, both the reasonable suspicion and the reasonable ground standard require the officer to consider all of the information inculpatory and exculpatory known to them at the time. But they don't have to engage in the argument of a defense. They just have to consider it. And then they can still say, this coupled with all of these other things, I didn't think that this was the medical condition. I concluded it was more likely going to be that alcohol impaired their ability to move or
Yeah.
drive. Yeah.
Now, some of the issues that we see, especially on the videos of when the individual is eventually taken to the police station and when they have to do the breathalyzer test, is that conversation with the police officer that could also be detrimental. So let's talk a little bit about how that can be problematic to clients.
Yes. So pretty much in an impaired driving investigation, once you've spoken to a lawyer or you've said, I don't want to talk to a lawyer and been very
Mhm.
clear and unequivocal about that,
Yeah.
every word that comes out of your mouth is now admissible as
Mm.
evidence against you. There's exceptions for things that happen pre your right to counsel in the roadside, there, some things might be admissible, but anything that's compelled from you in the investigative stages is subject to a doctrine called use immunity, where it can't be used against you as evidence. But once that lawyer call happens, it's open season. So, the best advice any lawyer is ever going to give you if you're arrested and you contact a lawyer is don't say anything
Mhm.
from this point forward and blow. Those are the only two things you absolutely need to know. But those statements also are often statements that people make that allow the police to get further information. People might talk about where they were or what they were doing, and that I've seen cases where the police go and, oh, I was over at Hank's bar and but I only had one drink. I'm not impaired. You'll see when I blow. And then the police are off to Hank's bar the next morning, getting surveillance footage, asking Hanks to turn over the receipts and the
Yeah.
point sale transactions, especially in serious cases. So people often give the police the investigative pathway by doing all of those things and by getting all of those statements out of them. And then, of course, they can also rely on the way that you're behaving at the police station, the way you're responding to questions to say that you're impaired. Your speech is slurred, your answers don't make sense. I have heard the strangest things come out of people's
Yeah.
mouths, police stations. Uh, and usually those are not the cases I like to be defending.
No, I know. I mean, like, okay, let's just talk a little bit about that because it is a big problem, I think, sometimes for clients who are in this situation because it is an awkward situation. They're sitting there in a room, weird, bizarre room, and there's this machine, and they're waiting for it to get ready. And the officer is there, and they're nervous. They have no idea what's going on. And sometimes I think some people feel like it's just to break the ice. They start talking, and that's when things just get from bad to worse. So, I mean,
When you're having to sit there, 15 minutes of silence can
yeah,
feel like an eternity. And
yeah,
we're not used to just like sitting with our thoughts anymore.
yeah,
It was
that's
probably
true.
a lot easier in the 90s, but now we have our phones. We constantly have something to entertain our brains. And now you're stuck there. You don't have your phone. Sometimes you're still handcuffed. And the police officer is, if they're smart, going to be trying to engage you in what feels like innocuous conversation.
Right,
Hey, did you catch the game last Sunday?
right.
Hey, I'm going up to my cabin this weekend. Do you have any plans? And you might think, it might lull you into this false sense of security that you're just having conversation to pass the time, but you're not. You're not.
Yeah,
They're trying to trick you. Everything when the police are talking to you, they're trying to trick you. Just operate on that assumption.
right. So, okay, so let's then talk about what happened. So they blew, like it's clear that they're over or they're 80 or over. The readings are, like over the limit. So is that the end, Stephanie? Like they're just like, so what happens then?
Well, usually, after that, they're going to be given a bunch of paperwork.
Yeah.
You're going to get a paper with a court date. You might get some release conditions if the officers are particularly not happy with you. If you have a bad record, you might be held for a bail hearing, but if it's your first time, you're going to be released on
Mhm.
paperwork, attend court in the future. You're going to get a date to come back to do fingerprints and photographs. You're going to get a piece of paper with your breath alcohol readings. And this is like the most important document that they can
Mhm.
give in an impaired case. They're required to serve that document on you. They're required to serve a true and accurate copy of the original on you. And they need to be able to prove that you were given that document with sufficient notice at trial. So if you get that paper, again, some of the best advice you can be given is keep it in a pristine condition, just like it was given to you, because any discrepancies may arise as a defense in your case.
All right. And can we also talk about because you mentioned a prior record can be a reason for them to be kept for bail, but there's also this notice of increased penalty that we also have that clients sometimes are not aware of, and how far can it go, like for them to invoke that?
Yeah, so any previous conviction for an impaired driving offense can trigger the police to give notice to seek greater penalty, which is essentially saying we're putting you on notice now that because you have a prior conviction, the prosecution may choose to rely on that to send you to jail. And with impaired driving cases, if it's a second or a subsequent conviction, the mandatory minimum penalty increases to a 30-day jail sentence and a 3-year driving prohibition. So it's a serious consequence. And don't panic though. If you get one of these pieces of paper, lots of police are just trained to always serve that
Hmm.
piece of paper. And Crown Counsel also have policies, and it varies based on province, but most prosecution services don't rely on that if the prior conviction is more than 10 years old. And I mean, usually if you're getting like more than 5 years, your lawyer can probably persuade them to disregard the previous conviction, and to proceed as though it's a first offense.
But they can still
They
rely on
can
it if they
still,
want
yeah.
to.
And
Yeah,
if they wanted to, they could rely on one from 1988.
right.
And you see them relying on that in the cases of the people who are the lifelong habitual offenders, who are consistently, they're prohibited from driving forever. They're consistently finding a way to get behind the wheel of a car while drunk and continuing to drive and continuing to flout the law. And that's why the criminal code leaves it open to rely on it at any point, because you don't want to not be able to rely on it for the people you need to rely on it on, but you want to give the Crown the discretion to say, I'm not going to for the people who don't need that as a specific deterrent.
Now, Kyla, you mentioned when it's a second or third impaired situation, then jail can be an option. But let's talk about the minimum, because there is a minimum punishment for impaired driving cases, and it's pretty bad because, I mean, sadly, especially in Ontario, you're going to be convicted if you're found guilty or you're pleading guilty. You're like, these are cases that unfortunately will cause people to have criminal records. So let's talk about the first time offender and the consequences. And now there's also immigration consequences involved.
Yes, so a first-time offender is going to face a mandatory minimum driving prohibition of 1 year, automatic criminal
Mhm.
record, and a minimum fine. And the fine amount is going to depend, if you're convicted of the at or over 80 offense, it's going to depend on how high you blew. So it's going to range anywhere between 1,000, that's the lowest, to 2,000 if your readings are above 150. Or if you refuse to provide a sample or fail to provide a sample without a reasonable excuse, then you face that $2,000 fine as the mandatory minimum. And because there is a maximum sentence available that is within a certain range, there are provisions of the Immigration and Refugee Protection Act that kick in. So anybody who is not a citizen and not a permanent resident of Canada is automatically subject to a removal order without any right of appeal. So you can just be deported from Canada once you're done serving your sentence. They don't deport you till you've served your sentence. So they make you sit around knowing you're going to be deported.
Yeah.
At least you have a year to sort it out while you're prohibited from driving. But once your sentence is up, off you go, you're out of Canada. For permanent residents, you're also automatically subject to the deportation or the removal order, but you have a right of appeal. And so you can apply to the super great immigration tribunal and say, please don't remove me from Canada, which is a little bit of mercy, but it is ultimately at the end of the day up to the government whether or not they're going to let you.
Right. Right. And you'll have to have an immigration lawyer at this point to help you with the situation. Now, because we're talking here about sentencing, what are some of the aggravating factors in impaired driving that people need to be aware of?
There are a bunch of aggravating
Yeah.
factors. So there's ones that are set out in the criminal code. Those include things like you're driving for your work at the time the offense occurred, so driving for remuneration, if you're driving a big commercial vehicle, elevated blood alcohol readings, even though it actually triggers the automatic higher fine, it's also a statutorily aggravating factor. Whether there's an injury or a death, again, that's usually going to trigger a more serious charge. But in circumstances where maybe you plead to a simple impaired when you're charged with impaired causing bodily harm,
Yeah.
the injury is going to be considered to be an aggravating factor. And whether you're prohibited from driving at the time that you are
Hmm.
given the charge, if you were also prohibited, then they are going to hold that against you.
Now, and in terms of driving prohibition, let's talk a little bit about that because, in addition to the conviction, the other disadvantage of the impaired driving situation is this loss of ability to drive. So let's talk a little bit about that. And actually, let's start with the first one because automatically, when you are arrested and charged, there is this 90-day impound, a 90-day driver license suspension, and your car, the vehicle will be impounded. So this is automatically, there's going to be that 3 months. I don't know if it's the same thing everywhere. In Ontario, at least,
Yeah.
there will be that. You'll get your license back, but then if you're convicted, then there's another lengthier driving prohibition. So let's talk a little bit about those.
Yeah, so every province in Canada has some sort of a roadside administrative prohibition that happens at the time you get charged.
Yeah.
Usually there's some sort of a vehicle impoundment associated with it. Where you are, it's going to vary based on the length in BC. For a criminal charge one, it's 24 hours. In Ontario, obviously, it's longer. And usually there's a driving suspension of 90 days. Most
Mhm.
provinces, it's 90 days. Some it's longer. Some you can end up actually suspended until your case is
And this
resolved.
is an automatic one, like because I know some clients there they want their license back so they can go to work, but it's an automatic one. Is
Yep.
there anything they can do just so people can know?
Yes, there are dispute processes. So each province will have an administrative tribunal set up that you can apply to dispute that automatic suspension. And usually with those administrative processes, because it's admin law, the burden is on you to prove your
Yeah.
innocence. And there are very limited grounds of appeal. And then after you get the criminal conviction, there's another license suspension that
Hmm.
happens automatically under the criminal code, but every single province also and the
Right.
territories also have automatic driving prohibitions that kick in under their own motor vehicle legislation.
Hmm.
Even if you had a situation where a judge didn't impose a criminal code driving prohibition, where they give you credit for time served if you were on a bail condition, or if the judge forgot to, it doesn't matter because the provinces are going to take your license away anyway.
All right. So, that's like in general for members of the public, some of the things that they need to be to watch out for. But what can we talk about for lawyers? Some of the important tips that we can give to lawyers in these types of cases.
I mean, my biggest tip for lawyers is because the criminal code really limits the statutory defenses, and there's not a lot you can actually argue on the science of the breath testing or things that affected the results. You've got to look for charter breaches. You've got to be really, really well versed in charter law, because that's your best pathway to succeeding in these cases is finding a breach and getting the evidence excluded. So my biggest tip is look for every single breach you can, plead every possible breach, even if it's like just a minor technical breach, plead it, plead every single one. Because the more breaches that you find, the more likely the breath readings or the evidence of the refusal is going to be excluded. There's potentially other remedies that you can get for charter breaches. And at the end of the day, prosecutors don't super love running lengthy charter litigation on impaired driving cases. So finding a bunch of breaches and persuading them that they may cause the evidence to be excluded can also help you resolve the matter without a conviction for your client.
And sometimes having multiple small breaches when you add them together might give you a stronger argument.
Yes. So the way the law looks at breaches is often if you have a pattern of breaches or a
Hmm.
series of breaches, it's considered to be more aggravating because it demonstrates a pattern of disregard for the accused's rights.
All right. All right, Kyla, anything else that you want to add about impaired driving that whether it's lawyers or members of the public should be mindful of?
I mean, I guess the biggest thing is for lawyers, if you have a difficult impaired driving case, call somebody who specializes in them.
Hmm.
There's people in every province who are really good at them, and everybody's really. I think every impaired lawyer in Canada is very giving of their time, and they'll help you out. And if you are a person who's charged with an impaired driving offense, get a lawyer. Don't try and deal
Yeah,
with it. They are complex, they are technical, and if you do it yourself, you are probably on a street shooting pathway to conviction.
right. And Kyla, where can people find you? I know you're very famous on social media, and especially Twitter, TikTok, probably all the known apps, but tell us where people can find you.
So, I mean, the easiest way to find me is on our website, vancouvercriminallaw.com. You can call our office, which is 604-685-8889, or like slide into my DMs on any platform.
People can find you on X. They can find you on TikTok. Know you've been also posting some very useful videos on impaired driving. So Kyla's very active on social media. So I encourage everyone to either reach out to her or to watch her and follow her on social media. She'll put some very useful information about impaired driving cases. Thank you so much, Kyla. I know you've been doing so much for WiCCD, and the series that we had was excellent. And thank you for taking the time again for this interview. And hopefully, we'll see you again soon.
Okay, thank you.